Well, welcome to the Law and Crime Network. I know you have been watching this morning, yesterday, last week, because we have a full slate of cases. But today, we have 2 death penalty cases we are still concentrating on. And they are, one, in Florida. As you know, Christopher Visada is being charged with the death of 3 people and the attempted murder of another. Look at that baby face there. You think he's a baby face? Well, he may be, but he also may be a killer. We won't know. And there's the victims who we don't concentrate on enough because they were murdered by somebody, if not him. Anyhow, they are in lunch break right now, and they're on lunch break because the prosecution rested this morning and the defense made the motion that we all make as defense attorneys, that is to dismiss the case, saying the prosecutors haven't proven their case, and yet the judge denied that. So what's going to happen next? We expect this afternoon the defense will begin their case with an expert testimony to try to refute the experts from the state. So we are monitoring that, and as soon as that goes live, we will go live. And then we also have another death penalty case. And I'll tell you, I thought the death penalty was out of vogue, but it turns out here we are at Law and Crime Network, and we have 2 cases. And that's the case you know well. It began in January of this past year. January, February, March, April, May, June. Oh, maybe even to July, we don't know. That is Charles Chase Merritt. He has been convicted of the murder of a whole family, the McStay family. There they are, the mom, the dad, the 2 children. Oh my God, again, those beautiful child faces. They went missing for years. They were missing. They left, last seen February 2010, were found almost 3 years later. It's tragic, it's terrible, it's horrible. And the jury says it was Charles Chase Merritt. So now what's happening is the defense is going to, and is, fighting for his life. They are going to say to the jury, we have many mitigating factors we have to say to the jury, please do not sentence my client, our client, this client, Charles Chase Merritt, to death. Oh my gosh, what a day it has been, what a day it has been, what a day it has been, what a week. Anyhow, after the verdict, which took many by surprise, guess what happened? The defense ran a press conference, as we know, a presser, and they said how shocked they were and how much time they're going to need to prep their defense for the death penalty. Let's hear from these shocked defense attorneys. It is so difficult when you look at little children like that who are just having so much fun to know that they were just brutally, brutally murdered. Whether they saw their mother murdered, whether they saw their father's body, I don't know. But I'd like to discuss it. I have with me, and you know her well, Janine Atamian. Janine, how are you? You are from Rhode Island, a state I also know well. Much of my family went to Brown University. Thanks. Yeah, Providence is fabulous.
It's wonderful. My office is there.
Yeah, that's fabulous. So you have tried a number of criminal cases, and you're well versed in the criminal law. I have a problem with this case, and not just with this case. If we have a case like we did on Law and Crime last week called Timothy Jones, he got the death penalty for killing his 5 kids. I mean, terrible case, no doubt about it. But there, his whole family said to the jury, please, I beg you, do not kill him for us. We are victims and we have constitutional rights basically under South Carolina law. Here, the family is coming forward for the prosecution and saying, please execute this defendant, Charles Chase Merritt. Where's the parity? Where's the justice in the 2 different states having 2 different rules?
Well, again, with regard to the Jones case, I get what you're saying, because even the mother of the children had asked that he not be executed. She was speaking on behalf of her kids. But again, you've got to look at the laws and what's going on in that particular state. While a lot of states are moving away from the death penalty, a couple weeks ago we had New Hampshire become the 22nd state, I think, to ban it. South Carolina is a little bit different in that they just a couple months ago had a Senate vote where they voted to not only bring back the electric chair, but to bring back firing squads. And so if your government is a reflection of the public and the jury is a portion of the public, your peers, it would make sense that they may have been more apt.
But we know there are thousands upon thousands upon thousands of cases that people were wrongfully convicted, and many of them on death row. Sometimes they came within like a day of dying for a crime they didn't do. How do we remedy that to be sure we have the right guy? Now in Jones, we know we have the right guy, right? But there's a lot of controversy in McStay.
In McStay, I can't believe he got convicted, first of all.
Okay, there you go.
I mean, I couldn't believe that he got convicted. So I don't think, I mean, again, California has a moratorium on the death penalty,
right.
So it's not necessarily.
What does that mean? What does that mean?
Meaning that their governor, a few months back, actually put a pause. So even though it's part of their constitution, you would have to have a state vote, but he put a pause on it. So nobody's going to actually receive the death penalty even if they are on death row. But obviously you don't want the sentence.
Yeah, but if he does get convicted of death penalty murder here, it may be beneficial, won't it? Because he'll get a higher standard of review, Mr. McStay, to see if there's errors in the trial, won't he?
That's correct, because this is going to be appealed. There's no way it's not going to be appealed as well. But as his attorneys, you don't want him to get that sentence.
Right.
And you can't believe he got convicted in the first place.
Right. Do you think, did you identify a specific error in the case that you thought was a big error?
They didn't do a lot with the blood that was on the table. That was one thing. And I think the antics between the prosecutors and the defense, so the defense was kind of skating a line with the third-party culpability, but they got it out there. So I just thought that those antics were kind of a turnoff for the jury. And they wanted to find someone guilty.
Yeah, and I thought the best piece of evidence, I'm not saying it was good, I'm not saying it was great, I'm not saying it was worthy of beyond a reasonable doubt, was the fact that that the defendant admitted he was the last person with Joseph. But then, couldn't this be a hit for hire for the mother? Couldn't it be like a group of people?
There's so many.
If there's three unidentified DNA profiles?
There's so many different scenarios. You know, you've got the guy that was in Florida, in Hawaii, or maybe not in Hawaii, Kavanaugh. There was a lot of different things. So the idea that there was no reasonable doubt is mind-blowing to me.
Should the judge have allowed in the statements that were on the computer that Joseph McStay saved that says, oh, we know Mr. Third-Party Possible Killer. I'm not going to mention his name, but we know what you're like, and you know, you can endanger my family, and all, and we could be in danger. Now we know that. Should the judge have allowed that statement in?
No, I don't think so.
Well, tell me why. This is interesting.
Because again, there's specific third-party culpability rules in the state of California, and some of the statements that the prosecutors wanted to get into happened after the fact, where he was threatening other people. I just don't think that I think it would have been too prejudicial to this particular case, and I think it was fair to let it out. He did let some of it in, but not a lot of it.
Well, we're going to have to see, because after this break, and you're going to stay tuned, we're going to talk a little bit more about Charles Merritt, and we'll be watching, as I can see up here, whether or not the Vesada case is back in court. Stay tuned here.